Hey, deputy, bring her back in here. Deputy,
Yeah,
you have something you want to say to me?
not you,
You
no.
were in my courtroom. I don't.
I was
appreciate-
walking away from your
You
courtroom
were
is what I
still-
was doing.
Ma'am?
I'm so tired of this system fucking me over is what I'm
Case
tired
number
of doing.
25
I
CR
really am,
43210, the state of Ohio versus Rebecca Curtis. You are Rebecca Curtis?
Yes, sir.
Ms. Nicholson is here on behalf of the state of Ohio. Can you tell me when she's scheduled to be in front of grand jury?
Her indictment was issued this morning,
She was indicted this morning.
so I do have a copy of that. I can serve her with. It is for 2 counts of assault on a police officer, felonies of the 4th degree, the 1 count of obstructing official business, a felony of the 5th degree, a misdemeanor 1 resisting arrest, and a misdemeanor 4 criminal trespass.
Okay.
For the record, she has been handed a copy.
Thank you.
We do have an arraignment entry if the court wants to arraign her today,
No,
or it's set for next week.
Yeah, she can just wait.
Okay.
Yeah, it's, she was just served, so she's got 24 hours. She might as well just set it for next week. Ms. Curtis, it's somewhat unusual for me to schedule this for hearing. Since I did not set your bond, I did not revoke your bond. Usually I only set these for hearing if I've revoked your bond from the lower court. Tell me why I should modify this bond.
Well, I'm just trying to be home for the holidays, really, if I can.
Officer, you have any information about this at all?
You're roped into the jail on the 25th. She'll have 25 days credit. I spoke with her over the phone yesterday and put all that information in the bond report. She provided a Middletown address. She reported she stays there a few days off and on, and then goes and stays at motels often. Reported she's not employed, that she's unable to get employment due to having cirrhosis and her mental health. And then she reported that she's currently in treatment with Butler Behavioral Health for PTSD, battered woman syndrome, human trafficking victim, but I was unable to verify that.
Got quite the record, Miss Curtis. Dating all the way back to 2008. I'm sorry. Goes on. I'm sorry, what keeps going on? 2002. Who do you live with?
My daughter.
The state have a request for bond?
Your Honor, this occurred all 75 back in November. So I don't know if it appeared that she was living there at the time. You know, I know I read in her letter that it indicated that she was in treatment, but alarming that this set of facts occurs while she is in treatment. Additionally, she was sentenced to prison in January for an ILC after an ILC violation, and was released about 4 months prior to this offense. She has a history of community control violations and not following orders given to her by the court. So I think if the court is inclined to release her, I mean, her bond is 100,000, 10%. If the court is inclined to modify that or to release her, we would ask that she be placed on electronically monitored house arrest. It sounds like she doesn't, I don't know how stable her living arrangements are. She does have a lengthy history.
Ms. Curtis, you were granted ILC by me in December of 24, so 1 year ago. Within a few weeks of that, you refused to go to the CBCF that I ordered. So I'm guessing you just wanted to continue to use the illegal drugs. So
That's
then
your
I think-
assumption, but I can drop urine and it's clean. I go to.
Well, you've been in jail for the last 30 days. I certainly hope that you'll be clean.
Oh yes, but I'm saying prior to that, you can
Yeah.
discuss it with Butler Behavior if you need to. I'm still going there.
Well, since you're gonna be arraigned on Wednesday, at this point in time, the court's not gonna modify the current bond order. I'll let the, you can make a pitch to the magistrates when they arraign you next week. All right, that's all. Hey, deputy, bring her back in here. Deputy!
Yeah. What is it?
You have something you wanna say to me?
Not you, no. No, sir.
You were in my courtroom. I don't.
I was walking away from your courtroom,
You
is
were
what I
still-
was doing.
Ma'am?
I'm so tired of this system fucking me over, is what I'm tired of doing. I really am, sir. It's not you directly, it's somebody else in this system. I
But when you
appreciate
wa-
you, I respect you, but I am not gonna keep letting this shit happen to me. I'm not. And other people. It's not you, it's somebody else in the system. That's all I'm saying. No disrespect to you. Have a nice holiday.
I am disrespected because when you use that kind of language in my courtroom, whether
Well,
you-
when I get mistreated by the system, you'd feel the same way, sir.
All right.
No disrespect to you personally.
But it
It's
is.
somebody else. Thank you, sir. I have a freedom of speech, you know? Like I said, fuck 'em.
This is case number 25CR43210, the state of Ohio versus Rebecca Curtis. Ms. Curtis is before the court with her counsel, Mr. Washington, Ms. Nicholson, on behalf of the state of Ohio. The court is in receipt of the report from the Forensic Evaluation Center prepared by Dr. Nichting. The date of the evaluation, February 12th. The date of the report, February 17th, 2026. Has everyone received a copy and had an opportunity to review that report?
Yes, Your Honor.
Yes,
Do we
Your
have
Honor.
a stipulation to the report?
Yes, Your Honor.
We'll stipulate to the report.
All right, based upon that, the court will make a finding that the defendant is currently incompetent to stand trial, and based upon the report of Dr. Nichting, that she is restorable to competency within the statutory period. The least restrictive placement for the restoration is summit behavior. Anything else?
Your Honor, I've prepared the entry and put in the language that earlier bed becomes available at Appalachian. She can be transferred there.
That's fine. Just watch it. Basically, if a bedded date becomes available at Appalachian Behavioral, we'll send her there to get it set. I don't want her just sitting and doing nothing.
Okay.
So the restoration, it just speeds up the restoration process, that's all.
Okay. Thank you, Your
All
Honor.
right, thank you, Mr. Washington.
Now what?
They're gonna take you either to Summit or to the Appalachian place.
CR 43210, the state of Ohio versus Rebecca Curtis. Ms. Curtis is before the court with her counsel, Mr. Washington, Ms. Nicholson, on behalf of the state of Ohio. Ms. Nicholson.
Your Honor, it's my understanding that the defendant is going to be pleading guilty to 2 counts of felony for assault on a police officer and then a misdemeanor for criminal trespass. The remaining 2 charges will be dismissed. There is no agreement on sentencing.
Mr. Washington, is that accurate?
That is accurate, Judge.
All right, Ms. Curtis, they're telling me that you're going to be changing your plea to certain counts from the indictment. Before I get to your change of plea, I am required to go over some things with you, okay?
Yes, sir.
How old are you?
53,
How far did you go in school?
8th grade.
Can you read and write?
Yes, sir.
Are you a citizen of the United States?
Yes, sir.
Has anyone promised you how the court would sentence you?
No, sir.
Has anyone threatened you in any way to get you to plead guilty against your will?
No, sir.
Are you satisfied with the representation that you've received from Mr. Washington?
Yes, sir.
Are you currently under the influence of any drugs or alcohol?
No, sir.
Do you take any type of medication that interferes with your ability to understand what's going on today?
No, sir.
Rendering a plea of guilty to 2 counts of assault on a police officer. Each of those is felonies of the 4th degree. Each of them carries maximum penalties of 18 months in prison and $5,000 maximum fine. The prison terms are not mandatory. The 3rd count is one of criminal trespass, a misdemeanor of the 4th degree. That carries a maximum penalty of 30 days in the Warren County Jail and a $250 fine. Do you understand the maximum penalties?
Yes, sir.
And it's-
Your Honor, if this case would have proceeded to trial, the state would have proven beyond a reasonable doubt that on or about November 25th, 2025, in the city of Monroe, Warren County, Ohio, the Monroe Police Department was called to the Motel 75 to remove the defendant who was refusing to leave the motel. She refused to come to the door. Eventually, law enforcement made entry and found the defendant lying in bed. She refused to identify herself, refused to get off the bed, refused to leave the hotel. Ultimately, they attempted to physically remove her, and during that process, she kicked Officer Toadman and Officer Gattermeyer, knocking at least one of those officers' body cams off his uniform. She made threats of violence prior to kicking them.
Mr. Washington, anything on those facts?
Nothing on the facts, Judge.
Ms. Curtis, did you hear the statement that was read?
Yes, ma'am. I mean, yes, sir.
Do you admit that what she said is true?
Yes, sir.
And again, you understand all the rights you're giving up when you enter a plea of guilty.
Yes, sir.
What is your plea?
Guilty.
The court will make a finding that you've made a knowing, intelligent, and voluntary waiver of your constitutional rights. The court will accept your plea of guilty, and based upon the statement of facts in your plea, the court will make a finding of guilty. I'm going to order a pre-sentence investigation, Ms. Curtis. We'll come back in a few weeks and do sentencing at that time. You wish to be heard, Mr. Washington?
Judge, with regard to bond, now that she's entered her plea, she's been in custody in some form or another since November of last year. And talking to her, my communication with her over the last month has been very, very good. I think she's done everything that we've asked of her up to this point, and I want her to have an opportunity to continue to do that, but do it outside the walls of the jail. So if the court would consider our bond for her, perhaps even with the EMU, if the court's more comfortable. With pretrial, I think it'll give us a nice window into what her ability is to maintain and to follow the rules. Obviously, I'm going to argue for probation when we come back for sentencing. So I'd ask the court to give her that opportunity at this point. Like I said, she's been locked up since November.
Ms. Curtis, where are you going to live?
At my daughter's, sir.
Where is that?
Middletown.
Where?
Middletown.
I have had an opportunity to confirm with her daughter that she can stay there, Judge.
She has that son with cerebral palsy. I'm going to help her with him.
I'm going to be honest with you, Ms. Curtis. Does the state have a position?
Your Honor, the state certainly understands there are some mental health, there is a mental health component here, but there's also a significant substance use component. And she has a history of non-compliance with this court. In December of 2024, this court sent her to prison because she refused treatment, and she had been out, I think, about 4 months when she committed this offense. And I don't know that we know, anyone here knows what the treatment recommendation level is going to be as it pertains to substance use or mental health. And so the state would ask that she continue to be held pending sentencing so that the appropriate considerations can be looked at. But the state does acknowledge she has been in custody in some form or another since November 25th.
All right, Ms. Curtis, in looking at your record, you do not have you have a history, I should say, of non-compliance with the terms and conditions of probation. So, your attorney is going to be arguing when we come back in here for sentencing that I should put you under community control. So I'm going to give you this opportunity. I'm going to release you today on your own recognizance with electronically monitored house arrest. If you don't comply with the terms and conditions of the monitor, if you go back and you start using illegal drugs or drink or smoke marijuana, you understand that I'm going to be sending you back to prison.
Yes, sir.
I mean, you have 2 assaults on police officers. The state's probably going to be arguing for prison anyway. So I'm going to give you this window to prove to me that you can, in fact, comply with the rules, because it's been as recent as a year ago you couldn't. If you continue to not follow the rules, that's where you're going to end up.
Yes,
So,
sir.
OR today, electronically monitored house arrest, and when you get out, you must come over and set up your PSI interview. Do you understand?
Yes, sir.
All right. Do you have any questions?
No, sir.
All right. That's all.
Judge, thank you.
Thank you.
sir.
No, agreed, 100%.
This is Rebecca Curtis. Ms. Curtis is before the court with her counsel, Mr. Washington. Ms. Nicholson's here on behalf of the state of Ohio. We're here for sentencing. Has everyone had an opportunity to review the pre-sentence investigation?
Yes, Your Honor.
Yes, Judge.
Ms. Nicholson, anything on behalf of the state?
Your Honor, we believe that a prison sentence is appropriate in this case. Ms. Curtis, at the end of 2024, was given an opportunity to complete a CBCF. She refused that, was sent to prison, got out of prison in the fall of 2025, and not long thereafter committed these offenses, which included her assaulting 2 law enforcement officers as they were trying to remove her from a motel room. So we would ask the court to send her to prison.
Thank you. Anything from probation?
Nothing.
Oh, I'm sorry. Mr. Washington?
Judge, I find the progress that she's made to be quite remarkable, quite frankly. Judge, I think the court remembers my first couple of appearances in this court where Rebecca wasn't quite herself and ultimately went to Summit and was restored. Even my conversation with her just now, when we were talking about what potential outcomes this could be or could have come, she was listening, she's receptive, and she now has indicated to me that she does want to engage in the Monday program. Speaking of probation, they were very, very helpful in terms of explaining all the support and programs that are available while she's there, as well as the aftercare. That's something that she's interested in, and something that she's indicated to me that she's going to complete. So I think that that's impressive from a standpoint of willing to be able to say, okay, maybe I don't have all the answers, and I'm going to listen to some other people that may have more experience or can look at things from a different perspective. I think just from that perspective, things are very different right now. We'd ask you to give her an opportunity with the Monday program or the
Start with Monday.
whichever program that is. Yeah.
Ms. Curtis, is there anything you'd like to say?
No, sir.
No? Look, this is the second time you've been before me, right?
Yes, sir.
Both of these involve you staying at motels,
Yes, sir.
right? The first time, I think it was Motel 6. This one was Motel 75. And that's really one of the reasons why when we were trying to confirm residence for you, staying at a hotel or a motel while you're on monitor was simply not an option. It just doesn't seem like that's the best suited place for you to be. I think we can work with you and try to get you, stable housing, things like that. But you've got to work just as hard. Okay.
Yes, sir.
All right. So, court has considered the statements made here today, the pre-sentence investigation, the purposes and principles of sentencing, and I am going to find today that you are amenable to community control. This mental health aspect of all of this, I think, is a big factor. So I'm going to place you into community control for a period of 3 years. You'll be subject to the supervision of the Warren County Probation Department. It's very important that you abstain from the use of any drugs, alcohol, or marijuana. With your diagnosis, you cannot use any of those substances, okay?
Yes, sir.
All right. I am going to order you to successfully complete a CBCF with recommended aftercare. You will be placed on monitor for a period of 90 days following the completion of that program. In between now and your completion of that program, probation is going to be working on housing for you, okay?
Yes, sir.
We've got to find something that is safe for you, that is sustainable, that is stable, okay? We can't have you staying in hotels. That's simply not going to work, okay? Looks like you have 254 days jail time credit. The court finds that you're indigent for the purpose of any fines, costs, or other financial sanctions. Do you have any questions for me?
No, sir.
All right. Best of luck to you.
Thank you.
Thank you, Judge.
Thank you, sir.
Your client can sit at the podium.
This is case number 25CR43210, the State of Ohio versus Rebecca Curtis. Ms. Curtis is before me on a probation violation. Officer, could you read that allegation?
Your Honor, in violation of special condition number 15I, on August 19th, 2026, the defendant self-terminated from the Monday program.
All right, Ms. Curtis, do you understand that allegation?
Yes, sir.
You have a right to be represented by counsel. If you cannot afford an attorney, I will appoint one for you at no cost. Do you have the funds to hire an attorney?
Yes, I do, but I'm okay with it. I'd rather proceed on.
You want to waive your right to counsel?
Yes, sir.
All right, Mr.
I have
Log?
one already, but I don't know where he's at.
Who?
David Washington.
Well, he was just here last week. on your case, right?
I have no idea.
Did you let him know about today's hearing?
Yes, sir.
Well, I will reschedule this then to have Mr. Washington here. I'm gonna find that there's probable cause that you have violated the terms of your community control. I am going to set this for final hearing. And we'll notify Mr. Washington of that date, okay? All right, thank you.